All right, this is Hodges against Hodges, and you may proceed when you're ready, sir.
Thank you, Your Honor. Bill Gressley from Jacksonville on behalf of the appellant Marcus Hodges. I have an unusual case here because we actually have several issues that Ms. Sussman agrees with me that are going to need to go back and be addressed. There are a couple of legal points that I think I need to discuss before I get to what's most important to my client, which is the time-sharing issue, but the money issues are important as well. The life insurance issue, the case law from this court and from the Fourth are clear that you have to plead entitlement to...
You had a case on it, or was it, okay?
Yes, I want to say it's Layeni, L-A-Y-E-N-I, that says you...
Why is that? I mean, when the child support statute gives the judge the prerogative to do that, why is it necessary to plead when you're just asking for child support?
Well, this court's decision in Layeni and the ZV something case, I apologize, I can't remember the pronunciation of it, out of the Fourth, both point out that there are, the statutory requirement is that it has to be, it can be granted in, quote, appropriate circumstances. This court's decision in Layeni talked about, in a footnote, the fact that some of the district courts had a requirement that it be, quote, special circumstances, but that the Supreme Court's decision had determined that it was the, quote, appropriate circumstances. That requires fact-finding. And I think that the fallacy in opposing counsel's position on this issue is that simply by asking for child support automatically is a pleading that entitles you to get insurance. I think that when you look at the case law, Your Honor, the primary reason for life insurance is if there is going to be financial devastation to the receiving spouse in an alimony context, or to the parent who is getting the life insurance to secure child support, that they would be financially devastated if the payor predeceased. We don't have that here. We've got two fairly young people, both of whom are employed at very similar jobs, and the child is 11 years old. There is no special circumstance, even if we want to assume that there is a pleading by simply asking for child support. The related type of issue is the issue about partition. But I don't want to forget to talk about all of the issues here so that I can address them on rebuttal. But the partition action, I was remiss in my reply brief in not addressing the Riley case that opposing counsel raised in the answer brief by claiming that you don't ever have to have a pleading seeking partition anymore because the court has authority, because the equitable distribution scheme in Chapter 61 is to be presumed that you're authorized to sell the asset. The case that is cited, the Riley case out of the Third, actually says that. It's mind-boggling that I didn't pick up on that. They said it in dicta, but all the other case law, including the Worthen case out of the Fourth, which was decided after Riley, have all said if you want partition of the real estate, particularly the marital home, you have to specifically ask for it and you have to put on evidence about it.
So so the trial judge can only give it to one party or the other?
Can only allow possession to one party or another. What the point of this particular...
Distribute it to one party or the other, right?
No, there are other options.
Distribute the house without...
You cannot do that if there are not sufficient assets. If there were sufficient assets to say, okay, and the figure was 120-something in this case. I mean, the trial judge has many ways to get around that problem. And most of the ones that I see that don't involve a partition is when the judge says, you, the person I'm giving possession of the marital home to, you're responsible for all the mortgage payments, et cetera, and you are to hold, your former spouse harmless from any claims against the home, et cetera, et cetera. There are many options, but my client asked for exclusive use and possession as a component of his request that he be the majority.
And on remand to add that in there?
I think the Judge, I'm sorry, my ears are getting a little old.
They amend their petition on remand if we say that...
If this court allows them to.
Well, I mean, is there any prejudice? I mean, we don't know what the circumstances are now. The circumstances have undoubtedly changed.
And I agree with that.
Final judgment.
You know, the typical rule of law is that the trial judge has discretion as to taking additional evidence, et cetera, on remand unless the District Court of Appeal has directed some other proceeding. And so the point I was making was that the way this record stands is there was no pleading. My client asked for exclusive use and possession because he wanted to be the majority timeshare parent and he wanted to have it as an incident of support. He said, I am going to try to refinance it and I'm glad to take her out and give her her money if I can do it. You're right, we don't know where that stands today.
Well, it doesn't look like he has the ability to do it. I mean, he was in default on the mortgage before.
Well, I had to laugh when you asked counsel in the first argument to essentially read your mind and say what you're going to actually rule. I wish I knew that. The real estate market has been a mystery, and I keep finding people that have assets that are having trouble getting mortgages and people that don't seem to be able to make ends meet or getting them. So I don't know the answer to that, Judge, and I'm not trying to avoid the question. I don't have a good insight into it. But yes, circumstances are most likely different. But the holding here is that yes, maybe there is a way to allow them to amend it on remand, but I think that the holding needs to be is that there was no authority for this to happen. If you look at the Riley case, that is the only legal authority cited by opposing counsel in the answer brief. That was a case in which there was a dispute as to whether a piece of property where the parties had lived was marital or non-marital. They each owned a home. The wife filed in her claim, dissolution petition, a claim for partition of that home. The husband said, it's not marital. The judge didn't make a decision. He just treated it as if it was marital without any factual findings to support that. And that's what the basis of the reversal from the third was. It's pure dicta that it says you don't have to make a claim for partition anymore. Judge has the authority to do that. So if this court is inclined to do that, you're going to need to look at the cases I put in the brief that hold to the contrary, because that will represent a conflict. The issue, I was the lucky lawyer who got to be on the wrong side of this court's decision in Lovell v. Lovell, which is being used for many different purposes now in family law cases. The one that's relevant here is that the court reversed on a couple of other issues, but pointed out that the guidelines, visitation schedule and the guidelines that were provided were contradictory and confusing as to when, I think it was summer vacation started, because the wife had been allowed to move to Utah and the husband was still here. And so the court said, you need to get this clarified because we don't need any more confusion. And my plea to you is you've got two parties who had experienced trial counsel and have spent the resources to get experienced appellate counsel to come argue about this, which tells me that there's not much chance that there won't be an argument unless it's clear. We have a parenting plan that says my client gets Wednesday nights overnight, takes Grace to school the next morning. The Seventh Circuit guidelines that are attached says you get Wednesday until 8 o'clock.
Unless otherwise impacted by an agreement, correct?
Well, that's Ms. Sussman's argument, and I think that
Doesn't the specific control over the general? I mean, in other words,
it should, but what's specific? Wednesday night at 8 or Wednesday overnight until school? I think they're both specific, and they are incontrovertibly
well,
conflicting.
if there's a conflict, doesn't the final judgment control over the guidelines?
Final judgment says that we're going to do it in accordance with guideline and then adopts the parenting plan.
Well, the guidelines are intended to flesh out anything that's not specifically articulated, right? I mean, isn't that what?
Well, they're supposed to be, and I'd sure like it, since you're going to, I hope, write an opinion of some nature to get us back to where we need to be, that you'll address this and say you need to clarify that that's happening. And the other part of this that's really important, because the basis for my client's fervency about this case is the time-sharing issue, is that in the final judgment, the judge grants each party a, quote, right of first refusal. It appears from my reading of it It appears to be for any time that the child is not going to be watched by a parent for more than 90 minutes, the other parent has the right to have the child. That was a major contention at trial. It's a major part of why my client has me here today. That's not very clear. I think that provision is also fraught with ambiguity and lays the groundwork for us to have to be back here and our
What does the
clients...
judgment say on that point?
I apologize.
What does the judgment say on that?
The judgments, I think I just quoted it to you. It says, let me look at, find it exactly.
What I'm
Child
trying to
support.
find out is how does that conflict with the guidelines?
I am sorry, Judge.
How does that conflict with the guidelines, what the judgment says?
It's an additional provision, but it's ambiguous, is what I'm saying, is that it's not clear what this means, and it's not clear, given the judge's reference to the guidelines and the attachment of the parenting plan, which specifies the Wednesday overnight. I'm submitting to you that this should be addressed, to specify it, or tell the judge, be very specific about what you mean, only because we...
What do you see as the ambiguity? So, what is the ambiguity?
Okay, the first thing that happens is the judge says both parties have to take the parenting class again. It's a good idea. They should keep the other, and I'm now quoting, the other informed whenever the child is being taken care of for more than 90 minutes by a non-parent. Each parent has the right of first refusal over the other parent. My reading of that is, if the child is going to be left with someone other than a parent for 90 minutes, the other parent has the right to, they live close, has the right to go and get the child.
My reading of it, too. What's the other interpretation?
I don't know that there is one, and I should probably have not used the word ambiguity. Ambiguity, I think that more accurately is this case, as it relates to child time sharing, has all the markings of an ongoing conflict, and whatever we can do to resolve those and get them clarified.
Parent, specifically, your client's concern was the
Teenage children.
Yes. The step.
Well, and it's a little, that is a specific...
Non-parent is non-parent. I mean, how would you have the judge clarify that?
Okay, then let's agree, and I'll be glad to show this to Judge Alexander, that's the understanding of what this means.
I'm just trying to find out what relief you want from us. We can't just send an order back.
No, I understand,
Explain
but-
what you meant here if we don't think that it's ambiguous.
I'm going to go with, it's not ambiguous. It just struck me on my 28th reading of this in my hotel room last night that this is just another place that we're going to end up
I
coming back
understand that it
again.
may result in a lot of litigation.
Right, but that doesn't make it ambiguous.
Litigation, but there's not a whole lot we can do about that unless we strike the provision, and you haven't asked for us to
No,
do that.
no, and I don't think that that's an issue. I think the issue that I had was we are facing a conflicting couple of provisions between the parenting plan and the guidelines, both of which have been referenced by the final judgment. We really could use the judge being very specific about which one controls. The next point that I want to make has to do with the child support calculation. Ms. Sussman's agreed that the judge picked up the gross figure rather than the net. My argument has to do with how he came up with the figure. Ms. Sussman says it's legitimate and a reasonable exercise of the court's discretion to simply make up a number that was less than the amount that my client earned in 2011, because in 2012 he started reducing his work hours. My primary argument is the only reason my client reduced his work hours, the only evidence in this record as to this, was so that he could be available to care for his daughter.
Well, that was his explanation of why he reduced his work hours. The judge
Exactly, and there's no other evidence.
accept that? I mean,
There still has to be evidence.
The trial judge is zeroed in on the children. And maybe the trial judge decided that earning more income is more important than having more visitation time.
And I don't think trial judges have the authority to do that in the absence of some evidence that that's an issue.
Well, but we know that he was going to the school and was,
Exactly.
I mean, he was spending, a lot of time,
Absolutely.
okay? Well, the trial judge could make a decision that wait a minute, you go back to earning some money for the benefit of the kids, and that's in the best interest of the children. I don't see that there's any prohibition for a trial judge making that determination.
Judge, there's a couple of responses to that. There was no testimony and no evidence that there was a lack of income to care for this child, that there was some issue as to income available to care for this child. And secondly, and I'm getting ready to go where angels fear to tread, but I left Holland and Knight 18 years ago to start my own firm so that when my children were 3 and 5 and 10 years old, I could go to their school and read stories to them. Those are things that I don't believe, in the absence of some finding.
Working 24 hours a week after you left Holland at night, right? 4 hours, the guy's working 24 hours a week, and the judge imputed some income to him.
Understand.
He was working 36 before.
Exactly.
Hardly a grueling schedule.
And I agree, but the problem is that instead of looking at why he became voluntarily underemployed, which was solely for child care purposes. I'm sorry?
There has to be a balance.
Yes.
And the judge could find that 24 hours a week isn't the right balance. That, because I understand that you don't want to, if you're working 60 hours a week at Holland and Knight and you want to watch your kids grow up, you can make a decision.
That I can work 80 hours a week on my own time, but at least I have the flexibility of when I do it.
I didn't say it was a good decision, but you can make a decision that you're going to work less hours or control your hours, and so you can, spend time with the kids.
Right, that, just to clarify, it was to...
There's a balance that has to be drawn, and it sounds like the judge in this case, was doing that.
And I understand the argument and the point. My point is simply there was no evidence that there was a financial issue that caused a problem for this child. There was no evidence of that. So you can say all day long...
Is that the standard, that there has to be evidence that there was a financial hardship?
There has to be, you can disbelieve a party's testimony.
Under that theory, when we have NBA players that get divorced, we could set some nominal amount of child support because the needs of the child are met, but the fact is that that's not how it works, because the child's going to get to benefit from the income level of the parents, correct?
That's absolutely correct.
You want to say some rebuttal time?
Oh, well, the last thing I need to touch on before I do what I always do, which is run over, is I understand that the factors in the statute to address, which factor favors which parent are supposed to yield a result that is legally defensible. This child had both of her parents available to her at different times throughout her life. They both were nurses who could control their own work hours. This final judgment now turns my client into a every other weekend dad. Grace, the child, has never had to deal with that before.
And I'm not unsympathetic to that, other than the standard of our review is abuse of discretion.
And what I think the answer to that is, and it bothers me, obviously, as appellant counsel, that's the big hurdle that you always face. But when you get to the end, and it says any other factor, the judge's recitations here focus on these two parents who did not do well. They did not play well together. That's why they got divorced, and they played worse together as they got through this process.
You seem to be concerned about some of the behavior of your client.
All of which are divorced from the factual moorings on which the testimony was given. The behavior of my client that he was concerned about had to do with him always wanting to know where his daughter was. And the reason that became an issue is exactly what...
Knocking on the door and hiding didn't have anything to do with knowing where his daughter was.
But the only thing he's got, the evidence he's got is a nosy neighbor who sees part of that and doesn't know what it is.
He found that nosy neighbor to be credible, though, Counselor. You know that.
I understand that, but was she competent to testify as to what she was seeing, other than he knocked on the door and hid behind the bush or whatever it was? Because he's worrying that these teenagers are in there smoking pot and doing God knows what else with his then 10-year-old daughter.
Okay. You got some rebuttal time if you stop now.
Thank you.
All righty.
May it please the court?
Yes, ma'am.
I'm Stephanie Sussman on behalf of the appellee, Laura Hodges. I think generally, there's three areas we're talking about today: the child support and the,
What areas do you concede, so I can get those?
I concede that the trial judge pulled the child support number off the wrong line of the guideline calculation.
Child support is wrong, right?
Correct.
Okay.
It should be the $140, I believe it's 65 cents.
Okay.
And I concede that on the life insurance,
Right.
that the actual written findings that are required or not in the judgment, I believe that there's evidence in the record to have the findings made, so I don't think the requirement needs to be stricken, but I think when it goes back for correction.
What do you say about the pleading issue on that?
I think both parties invoked the child support statute, and in reviewing the Leahy case that came out of this court, there's nothing in that case that says you have to specifically plead the life insurance request separate and apart from the request for child support. What it establishes is the necessity of having the written findings in the judgment, which we concede aren't there, but based on the record, we think there is sufficient evidence to
Right.
support that requirement.
All right, what else do you concede?
I believe those are the only two
Okay.
concessions.
What about the partition? What do you say about that? Is there
The
a law
partition,
that says you have to plead for that?
I think that there's conflicting decisions out of the districts in Florida. The Worthing case, which I believe is out of the fourth,
How about out of our court?
I did not find anything out of the fifth, and I looked again yesterday just to make sure.
The Riley case is the one case that seems to go your way, right?
Yes, sir. And the Worthing case out of the fourth, I think, goes the other way, but I think the reasoning in the Riley case, which cites to a Florida Supreme Court case, is more persuasive, in my opinion, in this case. I think that the equitable distribution statute was enacted by the legislature to give trial judges power to dispose of all marital assets and liabilities, and marital homes and the mortgages attached to those assets are sometimes the biggest issues in cases, especially recently with what happened with the real estate market. So when you have a case like this, or you have someone come in and say, I want a chance to refinance this mortgage because I want the house, and I acknowledge that I need to buy my soon-to-be former wife out of her equity, and the trial judge says, I'm going to give you the chance to do that, but if you can't, we still have to figure out what's going to happen to this asset, and he says it's going to be listed for sale. Maybe on a technicality, which I didn't raise this in the brief, but has he really partitioned it yet? I don't know, but I think we would end up back here on that issue if it's not addressed now. But what are trial judges supposed to do with pieces of real estate when you don't have a situation where there's enough other assets to offset the equity, which in this case, I don't believe there would be if this goes back and the trial judge is told, there was no partition requested.
Courts have always historically had to divide property in divorce cases, and yet there were requirements for the pleading of partition actions historically. Why would, the passage of the equitable distribution statute make any difference in that regard?
I think that because that statute was enacted specifically to address the division of assets and liabilities in divorces, and as the Riley court found, that's the statute that now these trial judges are acting under. Prior to the enactment of that statute, there was sort of this morass of law dealing with different assets that they had to look to. By having this statute enacted, it put everything under the ambits of that statute. It gave judges the power to do what they need to do, and despite the specifics of that statute, the standard of review on equitable distribution is still an abuse of discretion. So to say that this trial judge didn't have the discretion to say, Mr. Hodges, I'm going to give you the opportunity you want to keep this house that you have moved your girlfriend into, that you have defaulted on the mortgage on, but I'm still going to let you try and keep this if that's what you want. But if you can't do that, I still have to find a way to distribute it, to make sure that your former wife is bought out, or...
I'm missing how the girlfriend's got anything to do with any of those things that you just talked about.
I'm just getting into the fact that it's still at a discretionary standard. I think when you look at what the trial judge did, he had the ability to consider the totality of the circumstances. I agree that that's not relevant to the specifics of the pleading issue.
You wanted to tell us about it, why?
Well, I think it's relevant on the issue of the fact that the trial judge clearly could have had the discretion to come in and say, I'm not going to do this. I'm going to give it to Mrs. Hodges, or I'm going to have it sold. I mean, yes, clearly it's a good fact for my client, but I agree it's not relevant to the pleading issue as to the partition itself. So with relation to the marital home, I think that under the Riley case, under the
On the
equitable,
marital home, the husband was the petitioner. He asked for ownership and exclusive possession. And
Yes.
your client agreed with that, right? That he should have ownership as long as she could get her equity out some way, right?
her position was, if that's what he wants, I have no objection to that. She had already moved out.
My equity,
Correct.
right.
And I think the trial judge fashioned,
Set a valuation that indicated that there was equity in the home.
yes, Your Honor. And his solution to that problem was either refinance or sell.
Refi for 6 months or whatever it was, and if you can't, then you're going to have to sell it to get the equity out.
That's correct.
There was no other way under the asset situation of these parties to give her equity other than to sell the house, right?
Because of the marital liabilities, there was no way to compensate her for that equity.
And how much credit card debt was there?
There was a substantial amount of credit card debt. I think, I'm sorry, I don't know the total off the top of my head, but it was, when you combine the credit card debt with the mortgage and the other liabilities, there was,
Like over $50,000,
Yes, sir.
right?
yes, sir. So, there weren't a lot of options available, and I think that the option the trial court chose was an equitable one. I think it was well within his discretion. I don't think he was required to have that specific pleading under the Riley case, under the equitable distribution statute, and I think that if this...
Did you all have the attorney's fees hearing below? What happened on attorney's fees at both parties?
Each party bore their
Each
own.
party?
Yes, sir.
Are there attorney's fees motions for the appeal?
I have not filed one, I don't believe. I mean, essentially, these incomes are so similar under the law, I think we both acknowledge that's not a likely result and probably not worth our client's money to have another hearing on that issue.
And do you think there are ambiguities in the time sharing?
I don't. I think that if you read the final judgment as a whole, it incorporates the Seventh Judicial Circuit guidelines, which if you read those, I think the trial judge's concern with the parents' communication in this case, with their dealings with each other, separate and apart from their dealings with the child, there's some directives in those guidelines that I think this trial judge thought would be helpful in this case. I think that he adopted the parenting plan, which actually was proposed by Mrs. Hodges and gave Mr. Hodges more time sharing than the guidelines. I know we can't discuss what's happened since then,
The
but
90-minute issue is a recipe for disaster in terms of post-judgment contempt motions flying.
I don't disagree. I think that, if it hasn't happened already, it probably will, but I don't think that
They live, what, 15 miles apart or within the same, or 5 miles apart?
they're
right?
very close, and they're very close to the child's school. Do I personally agree with the 90-minute
Well,
first?
it's not our recipe,
Right,
and, if it is, it is.
right. So do I think there's any ambiguity on that issue in this final judgment? No, I think that's what it says. If either party wants it changed, that's what modification actions are for, that's what enforcement actions are for. I don't think there's ambiguity there because it doesn't say anything different either in the parenting plan or in the Seventh Judicial Circuit guidelines. As to the child support issue separate from the life insurance, really focusing on the imputation of income, I don't think that the way that Mr. Gressley was discussing the standard for that is legally correct. The child support statutes explain that income can be imputed if a parent is voluntarily underemployed. There's no requirement for any finding of financial hardship or anything like that. The reason income is to be imputed is so that parents use their best efforts to earn income unless they have a good reason not to be. And in this case, the trial judge clearly did not think that Mr. Hodges' reasons for not working full-time as he had in the past were justifiable. And I think his behavior was really what played into the trial judge's decision because, the trial judge acknowledged him going to the school and having lunch with his daughter all the time, which I don't think is a negative thing, but he did mention, none of that started until these parties separated, which is a factor for courts to consider in all these time-sharing decisions. If all of a sudden a parent does a 180 in their behavior and starts becoming way more involved than they ever were in the past, which there's some indication.
Well, there was a lot of indication she wasn't involved at all.
Well, I think there was indication both ways, but the trial judge has the discretion to determine which evidence weighs heavier. He has the discretion to determine the credibility, and as he expressed in the final judgment, there were certain things that were of specific concern to him. There were certain things that I think maybe, pushed the scale one way or over the other in his opinion. And I think when you have a party, like in this case, who says, I'm cutting my hours back, I'm going to show up at the school all the time, I'm ringing the doorbell at night, there was evidence of the relationship between him and the half-siblings becoming somewhat hostile, him having physical confrontations with the father of the half-siblings. I think in the totality of all of this, those are the types of things that cause a trial judge to have concerns and to clearly played into the time-sharing schedule he issued. And I think the statement that Mr. Hodges now becomes an every other weekend only dad is not the case. I mean,
Well, I think that the concern that I have may be the same one that Judge Cohen expressed. There was no attempt to get back to the status quo. The status quo during the marriage was that these two parents cooperated and had a lot of flexibility on which shifts they were going to work. So they cooperated so that the child would have maximum time with parents, would always be with a parent, which is obviously very beneficial to the child. So what the trial judge did here was, instead of maintaining the status quo by forcing the parents to coordinate their schedules and do what they were doing during the marriage, which could have easily been accomplished, is put them in a modified sharing arrangement where they've got this 90-minute, 90-minute window, which we have two parents that are probably never going to get along, it looks like, and now they're in a situation that is going to result in a lot of contempt hearings. So, I mean, what do you say about that? I mean, shouldn't the trial judge have just put them back kept them in the status quo? Wouldn't the status quo work just fine here?
I don't think that that's the standard. I think that if what was supposed to happen in divorce is that you maintain the status quo, that's what the statutes would say.
There does come a point in time where we can say that discretion was abused, right? I mean, we do have the prerogative to say that the judge overstepped the bounds of his discretion, right?
I think you could, this court always has the option to make that finding, but I don't think the evidence, the record supports that in this case, because the status quo was destroyed initially by Mr. Hodges when he cut his work hours back, when he started doing some...
That's a he said, she said. He says that the status quo was destroyed because she wouldn't tell him what shift she was working anymore.
Well, but the trial judge didn't, I mean, his findings were in line with her testimony, and
Right.
as, we stand here today, we're not supposed to reweigh those conclusions. He sits in judgment of the credibility, he sits in judgment, he has that discretionary authority, and I think Mr. Hodges initially destroyed the status quo. I don't think, if a psychologist had testified at this trial and said, what's best for this child is to put this back the way it was, I think we'd be in a little bit of a different posture, but that's not how the trial was conducted. And so the status quo did not exist at the time this trial took place. The child was already experiencing a different arrangement, a different environment, and the trial judge had to figure out how to best deal with that. And I think the solution it came up with was a reasonable one. It was within his discretion. It's not a decision that we can sit here and say no reasonable judge could have reached under the facts of this case. Nobody is saying that, this isn't a case where we're dealing with abuse and things like that. There's nobody saying that Mr. Hodges is a terrible father, but there were some troubling things that went on. I think to go ring the doorbell of a home where there's 3 children and hide, I don't think there's any real explanation of that could have been put before the trial court to make him not concerned about that, and to say just because it was a neighbor that saw it and she doesn't know what was in his head. I mean, if he really thought there were teenagers smoking pot in that house with his 10-year-old, I mean, the reasonable thing would have been to call the police, not go ring the doorbell and hide. So I don't think, regardless of what his explanation was, that could have been done away with. And I think, the tracking device on the cell phone, the recording of the depositions, just this kind of behavior that this trial judge, sitting in the presence of these witnesses, heard about, for whatever reason, that concerned him about Mr. Hodges' intentions, Mr. Hodges' state of mind, Mr. Hodges' conduct. The totality of the picture painted for this trial judge led him to make this decision, and I don't think it was outside of what his discretion allowed him to do. And I think the first right of refusal really although I think we all here probably agree it could be a problem, it does give him some of that time back that he's complaining he's not going to have under the schedule, because if she's at work and he's not at work, then, you know,
I mean, that she communicates that schedule to him.
assuming, and I think that the trial judge put some safeguards in place for that to happen. You know, he was pretty direct in his directives to these parties about retaking this class, about being better communicators, and again,
That'll do it. The class will take care of it.
I understand realistically that's generally not a solution, but I think the point is that this trial judge was not sticking his head in the sand as to that issue. He did what he thought he could do, or at least put some things in place to begin to address that issue. All of us that deal with family law cases know that that's the kind of issue that causes cases to be litigated for a long time unless you have two people that just all of a sudden realize it's not worth it anymore. And hopefully that's the direction this case goes. You know, none of us can answer that question based on the record that's before us right now. So I don't think there's a basis for overturning the time-sharing schedule based on the standard that has to be applied, which is the abuse of discretion standard. I don't think that there's a basis for saying that the way the marital home was resolved has to be undone. That's, the equitable distribution is also an abuse of discretion standard. I think on the evidence presented and the facts of this case, the trial judge acted within his discretion in giving Mr. Hodges the chance he wanted to refinance, and then saying, if you can't do it, we're selling this house. That's the only way for Mrs. Hodges to have received her equity in the house. There was one conflict in the briefs that I just want to address as to the abuse of discretion related to the marital home. I believe in the initial brief, they claimed that this court could apply a de novo standard of review because of the failure to apply a statute or the misapplication of a statute. And I just wanted to make the point to say that the cases cited in support of that don't actually say that, and that any case relating to partition and equitable distribution, they all say that the standard of review is still abuse of discretion. So I just...
Well, what if the trial judge had no authority to, because it hadn't been pled? What would the standard be for that?
Well, misapplication of a statute would be a de novo standard of review, but the authority cited doesn't say that. I didn't, in dealing with the distribution of a marital home and a partition of a marital home in a divorce case, everything that I found discussed it, you know, under the abuse of discretion standard. So I think that's a standard that should be applied, even if you're, especially under the Riley case, which, you know, because it's based on the case out of the Florida Supreme Court, we would argue that that reasoning should be more persuasive.
And you've done the research, and you say that there's no case out of our district that mandates before the house can be sold that a partition action be pled.
I did not find anything. I tried to search it a lot of different ways. I did the shepherdizing of the Riley case and the Worthing case, and nothing out of the fifth DCA came back. So I did what I feel like was exhaustive research, but unless there's any other questions from the court, I feel like we've covered everything.
All right.
Thank you.
You got 38 seconds left, counsel, and she didn't use all her time, so I'm going to hold you to it.
Yes, sir. Very quickly, to clear the record, there is no girlfriend living in my client's house. The insurance issue we need, I addressed it in the brief. The final judgment names the former wife as the beneficiary, and that's wrong across the board. So that needs to be addressed as well. The partition case, if I spend my life writing briefs, if I picked up a wrong side on de novo review, then my bad. What the real standard is the trial judge did not have a pleading requesting that, and that is a misapplication of law. If you go with the Riley decision, then just say it so we know what...
Over time. Thank you.
I still have a question. Did you find any case out of the Fifth that requires that?
I did not. On page 8 of my reply brief, I've listed all the cases that I found, and like Ms. Sussman, I didn't see anything from this court on that issue.
All right.
Thank you,
Thank you, Your Honors.